What's up, everybody? Welcome back into another episode of The Lawyer You Know, and we are back talking about Sarah Boone. She has written another letter. She's making more complaints. She's having more potential lawyer issues, and we're in the appellate process, and we've been here for quite a while. There are a lot of appeal deadlines that should have been long gone by now, but hers keep getting extended. Is she happy about this? We know the appellate process is mostly in writing and research. Do lawyers even have to talk to their clients during the appellate process? We're going to talk about that. And we're going to take a look at the docket for her appeal, see what's going on, see what we can expect to happen, when we can expect it to happen. And does she have some legitimate gripes? Does she have some legitimate things that she can complain about at this point? Are her rights being violated? We're going to look through everything we have, all the updates. We're going to read the letter together and, of course, answer your questions. Let's get to it. So it's interesting that it feels at some point like we're coming full circle with Sarah Boone. And it's not quite all the way around yet, but I can foresee some similar issues coming for Sarah Boone at some point in the future. But I wanted to kind of talk through the appellate process, where we're at in Sarah Boone's appellate process, why it's taking so long, how long some of these appeals can take, answer your questions as well, because a lot of people have sent me in questions just generally over time about Sarah Boone, because I think she's still talking to people. She's still out there. She's still writing letters, obviously. How much back and forth will she get with the appeals court? Not as much as with the court, the trial court. But when we talk about the appellate process, we all know that within 30 days, your lawyer, and usually the trial lawyer will do this, has to file a notice of appeal. And James Owens did that in this case. And he's actually listed on the website. Let me bring up the website here so we can kind of look at this while we're talking. You can see it better like this. So it says James Owens here as the lawyer for Sarah Boone. We know she's been through a bunch of other lawyers. But the notice of appeal was filed all the way back on February 3rd. So that portion of the appeal was done properly. And because it was done properly, we are in this appellate process. So usually once that's done, there's a 70-day deadline, which is, 2.5-ish months for them to file her initial brief, okay, which is the first part of her appeal, basically your first bite at the apple. And what she can argue about in that initial brief is that Judge Kranick screwed up. We saw the motion for new trial. We saw some kind of preludes to some of their arguments, but basically some of the top ones I can think of that I remember back that they argued that happened in her case is very obviously the fact that Judge Kranick found that she constructively waived her right to counsel. That's going to be a huge part of this appeal. That's going to make this appeal interesting because we really haven't had a lot of jurisprudence on that issue. And if they're going to win on an issue, it's probably going to be that, coupled with the fact that James Owens jumped into this case and asked for a reasonable continuance, for which Judge Kranick said, no, you came into this case, you saw my order, you saw that I was not going to allow a continuance, you still decided to take this case, you had to try it. More on that later, that issue of not having enough time to prepare. But that's going to be, I think, the number one appellate issue. And then, of course, you have some of the other things they argued about, like prosecutorial misconduct. They did a second closing argument, or there was an outburst by a victim's family member, which, again, I think are not strong appellate arguments. And then another one that I think is okay, but I think Judge Kranick handled it perfectly, when I was frustrated when one of the prosecution witnesses came with an undisclosed opinion or a new opinion that they never told the defense about. That's frustrating. I just think Judge Kranick should have said she can't testify to that. I don't think the prosecutor needed it, frankly, but I do think that's going to be probably their second best issue. But Judge Kranick did his best to handle that issue, to resolve that conflict, to cure that problem by allowing the defense to kind of take her deposition again in the middle of trial. Now, did he provide enough time for them to prepare a new cross-examination, to talk to their expert on how does their expert want to respond to this new expert opinion? So I do think there's some problems there. I think that's probably her second best argument on appeal, but she does have some very legitimate arguments that if a lawyer were to draft and put together an appeal for Sarah Boone, that her rights should be protected, and this should be appealed up to the higher court to make sure Judge Kranick made the right call. And so the higher court in this initial brief will look at everything Judge Kranick did. They will presume Judge Cranick to be correct. Okay. It's not like we love overturning things in America. So it's unusual that you win appeals. If you go back and listen to my podcast with Michael Ufferman, who I think is one of the best, if not the best, appellate attorneys in Florida. He literally writes the book on appeals. He is Charlie Adelson's appellate attorney. We do a full deep dive and breakdown of the appellate process there. And he says that less than 10% of appeals are successful, that his are a little higher than that percentage, but generally speaking in Florida, less than 10%. I don't expect Sarah Boone's to be any better than that. So in this process, how this works, you have to order the trial transcripts, order the evidence, do research, pick out the best issues, make your arguments, see what other cases most closely align with your case that reversed for these reasons, and try to make that argument. And a question that I get all the time is, do appellate attorneys really have to talk to their clients? If she's complaining that her lawyers are not talking to her, is that really a big deal in the appeals process? And from my perspective, the answer will always be yes to that. If you are going to represent a client in Florida or anywhere else, you need to talk to that client. They need to discuss, and we've done criminal appeals before. I've worked on them with my dad. And you have to talk to your client about it and explain, here are the issues we're looking at. Here are why we're looking at these issues. And the client sometimes will say, well, what about this? Why didn't they let us do this? Why didn't they let us make this argument? We said, it's not a good argument. And if we have 25 issues, we're less likely for the judge to focus on our really good issues. So that's why we're only picking 4 issues. But a client has a right to know that, to know why you're picking certain issues and not others. And at the end of the day, it's the lawyer's call for strategy. But if a client really has a problem, like Sarah Boone might, you could try to fire that lawyer. You could, have a conflict, get a new lawyer, or constructively waive your right to counsel, which could obviously be an issue for Sarah Boone, as it was at the trial court level. So Sarah Boone, in my opinion, has an absolute right to speak to her lawyer through this appellate process. And if we take a look now at the last couple things to happen in this case, there was, because again, we have that 70 days, and that 70 days is long gone. So how did Sarah Boone already miss her opportunity? We've kind of talked about this already in another video, but just to keep everybody up to date, for those of you that may not remember, the appellate court granted a motion for extension for Sarah Boone. And this is because she's going through so many lawyers, right? And they granted it on September 16th, and it was granted for a 60-day extension from the date of this order. So November 15th-ish, right? Which is less than 2 weeks from now, this initial brief should be done. So at this point, if we're handling the criminal appeal, we've already done drafts of it. We've already talked to our client about it. We've maybe sent our client a draft, done the edits, talked about finalizing it, make sure we've got all the T's crossed and all the I's dotted. Now we're in the final stages of this appeal. It also says no further extensions will be granted absent in extenuating circumstances, aka good cause. So let's say, for example, they ordered the transcript didn't come, they can't write the appeal and cite the transcript and all the things that happen at the trial court level without the transcript. So if the transcript is not there, the court will, must, shall, and should grant another extension if that's an issue in the case. But what if there's a difference of opinion? What if there's a scenario where a client is trying to talk to their lawyer, can't get a hold of their lawyer, they have a right to, the lawyer's obligated to, the lawyer's hired on the case and should know that this is the appropriate thing to do in this case and every case? Well, that brings us to Sarah Boone's most recent letter to the court. In the Circuit Court of the Ninth Judicial Circuit in and for Orange County, Florida, state of Florida, notice of inquiry. Comes now, appellant Sarah Boone, and files her notice of inquiry with both the 6th District Court of Appeals and Orange County Clerk of Court, stating the following in support of. After appellant's first court-appointed appellate attorney, Alan Holland, December 2nd, 2024 to February 18th, 2025, was granted his motion to withdraw, Joshua Adams was appointed by the court to represent her and submit the initial brief in and for her criminal appeal. And basically, we remember this lawyer that was on the case for 2.5 months did literally nothing. Literally nothing. So you can't hold that against Sarah Boone. People saying, I wouldn't want to talk to her either. I get that, but you're not her lawyer. You're not getting paid to be her lawyer. You don't sign up to be a lawyer, right? So here we go. Sarah lies. I don't believe her at all when she says she can't get a hold of her lawyer. May Sonk says. That's fine if you want to believe that. But what are you basing that off of? Are the lawyers responding? Are the lawyers going to come out and say, no, we've spoken a bunch of times. We've gone through everything we need to do? Because that happened a little bit at the trial court level. They were like, this isn't true. We did talk. All right, so Mr. Adams ends up getting appointed after Alan Holland. During Mr. Adams' time frame of 7 months, February 18th to September 5th, in his representation of Ms. Boone, which included filing 2 extensions to continue doing so, he made the decision to withdraw without submitting her initial brief, citing he is no longer practicing appellate work or accepting court-appointed appellate cases. So this lawyer worked on her case for 7 months, and it seems like also accomplished nothing. People are saying they're not private lawyers. They don't know her anything. I think some of them are private court-appointed lawyers. And yes, they do. Private lawyer, public defender, doesn't matter. You do owe it to your client to talk to them, to speak to them when you represent them, if they want to. You can't just ignore them forever, not answer any of their questions. That's just not the ethical, moral, or right thing to do. We're a profession of ethics. We have a code of conduct and a code of ethics. If you don't want to have difficult clients, don't be a lawyer. Don't be this kind of lawyer. Don't be on court-appointed cases. No lawyer is going to boo-hoo about a difficult client. I'm sorry. No real lawyer who's actually practicing law, right? And has done it for some period of time. We've all had difficult clients. We've all had to talk to clients when we didn't feel like it. That's part of it. People can say lawyers are overpaid. Fine. They have to do stuff people don't want to do. And obviously, public defenders are not overpaid, and they got to talk to some of the most difficult clients in the world. So Bodie asked a good question. Did the lawyer get paid that didn't do anything? So my assumption would be no. If you didn't actually clock any hours, you shouldn't get paid. But if they did clock hours, it is reasonable to believe that they did get paid. But I do have an issue with that too. Florida taxpayers are paying these lawyers who are switching jobs, no longer taking appeals, bouncing off of cases when they literally accomplished nothing. Now, if the lawyer did some work and read the transcript and ordered the transcript and got the transcript printed so he could give it to future lawyers, then fine. At least he did something to move the ball down the field. But if they literally did nothing and then withdrew after accomplishing literally nothing for Sarah Boone, I have a problem with that. It's not how it should be. And I don't know that that's what happened. Okay, so this lawyer, 7 months, he filed 2 extensions because if you remember, the first extension was denied by the appellate court because he didn't consult with the other side, which you have to do, but it was a procedural issue that, you have to consult with the other side. So he did that after it was denied, filed another motion for extension. That's the order I just read to you that was granted, extending the case until November 15th-ish. Joshua Adams corresponded with appellant in one public access tablet message on February 27th, 2025, briefly introducing himself with no follow-up or continued contact to present date. Okay? So this guy represented her from February 18th to September 5th and only spoke to her one time on February 27th. So about 9 days into his representation, he introduced himself via the public access tablet. Is Sarah Boone telling the truth? Well, folks, from time to time, there are unanswerable questions for the lawyer you know. I don't know if she's telling the truth, but I will say that you can prove at least some of this, right? If you came to the jail, if you logged anything, if you did talk to her on the public access tablet, all of that would be documented. All of that would be easily provable or disproven. So I don't know if she's telling the truth, but I would assume that there would be a way to tell. It's also by the way, I'll just tell you right now what Sarah Boone is highlighting, and people can say whatever they want. And a lot of people in the chat are going to say, oh, haha, it's Sarah Boone, or good, it's Sarah Boone, or this is what she deserves. At this point, she deserves life in prison. That's what I think she deserves. But as a convict who has appellate rights and has an appointed attorney who's getting paid by the state of Florida, she also deserves that lawyer to do his job or her job. That's simple to me. You can deserve both things, life in prison and get your just return on your actions and still have these rights. That's the way it's written, and we want to protect and make sure convictions are correct. but she has a right for a lawyer to talk to her. Okay. And what she's highlighting is, yes, this may or may not be happening to Sarah Boone. It seems like it is based on what she's saying, but this happens to a lot of other people too. And I think more people, obviously, in this chat probably have experience about being in the hospital without somebody helping them versus being in jail. But let's assume you're in the hospital by yourself. You know how hard it can be to advocate for yourself. And if something's wrong or somebody doesn't show up or they're late or one doctor says one thing and a nurse says another and a PA says another and you don't know what to believe, it can be very difficult to figure out what's going on. And a lot of those people fall through the cracks. Bad things happen to them, or they get lucky and they're fine and they leave the hospital. The same thing can happen to people in prison. You don't speak up for yourself. You never hear from your appellate attorney. You lose and it's over. That is your one bite at the apple initial appeal. And by the way, there's 3 things the appellate court can do with an initial appeal. They can obviously, you can win and they can reverse it back to the trial court level. We saw that in the Take Care of Maya case, even though it was civil. That's what it looks like when you win an appeal. You can throw out cases or charges or causes of action and then reverse and make them retry other ones. That's one. Second, you can, balloons, congratulations to somebody. Number 2, you can lose and they can affirm the lower court and write an opinion explaining why they affirmed what the lower court did. That provides somewhat of an opportunity. It's pretty slim, but then you can appeal that up to the Florida Supreme Court potentially, or even file a habeas petition saying my federal rights were violated. We'll talk about that a little bit later. But the more common approach nowadays in the appellate courts in Florida is a PCA affirmed, which that opinion is one word, and it just says affirmed. And a lot of times, if a lawyer doesn't care, they don't do the best job, they don't talk to their client, they file the appeal to make sure the right's protected, they're going to get a PCA affirmed, which makes it virtually impossible to appeal it up to the Florida Supreme Court because there's nothing really to appeal at that point. So those are the 3 things that can happen. And her future rights can be affected by this appeal. Remind me before I sign off to talk about the 3850 ineffective assistance of counsel potential that this case has as well. All right, let me answer a couple questions. I work in a men's prison. I have to treat everyone the same. I assume everyone is in here for check fraud and I move on with my life. They still deserve the same health care that everyone else does. And they don't deserve you to be abusive to them, right? Treat them like a human being, even if they're a convict, even if they're a prisoner, even if they're a criminal, even if they've done horrible things. Do your job appropriately, right? They still have civil rights. Not the same civil rights that we have. A lot of their civil rights have been taken away from them, but some still do exist. Sandy, Sarah has said no communication with all lawyers. Her expectation is communication could be higher than what is reasonable. I agree with you 100%. They don't have to talk to her every day. They don't have to talk to her nearly as much as a trial lawyer would during that phase of the case. Absolutely not. Absolutely not. I'm not saying they have to talk to her every day. I'm not saying they have to be at her beck and call. I'm not saying they have to come and meet with her as often as she wants to meet with them. You heard what I said. Here are the issues in your appeal, Ms. Boone. Here's a draft. Tell me what you think. And they don't even have to necessarily take what she thinks and make changes. They can be like, nope, that's not what the law is. This is how we're going to file the appeal. Here's your final reason. But she should know what's happening, that an appeal has been written. There's a draft. This is what they're doing. Now, if she would have written a letter saying, I disagree with one of the points they made or the argument they made, or I found a case that they didn't find, or they should argue this case and not that case, that's a nothing burger. That's a nothing burger. And no court should ever really look at that. All right, so she says they've only spoken that one time. As of the date of this filing, appellant has no understanding of whom her present appellate attorney is, the current status of her appeal, nor the preparation of her initial brief as a result of no communication or inclusion from any party, including both the 6th District Court of Appeal and or the Orange County Clerk of Court. So the appellate court is not going to keep you up to date like the trial court is. That's not how it works, right? They're not going to keep you up to date. They're not going to call you into the courtroom. They're not going to ask you if you have any of the objections of your own. They're not going to handle you with kid gloves like the trial court will. That is just not. But if this is true, and this paragraph 4 is something we're going to come back to in a minute, that's a problem. Wherefore, appellant Sarah Boone respectfully files this notice of inquiry, which is not really a real thing, to request pertinent information regarding the updated name, contact, phone, and address of the successor court-appointed counsel to represent her and the status of her appeal, including the filing of the initial brief in this matter submitted this 27th day of October. So that's last Friday. Sarah Boone, certificate of service. I love the way she does this. She takes it very seriously, okay? She even puts her certificate of service. So we're going to focus here on these last two paragraphs. And to do that, I want to pull up one of the more recent filings in Sarah Boone's case. Let's take a look at this together. Order on counsel's motion to withdraw. This was filed on September 12th, okay? Almost 2 months ago, right before the extension was granted on September 16th. And a month and a half before Sarah Boone wrote this letter. Order on counsel's motion to withdraw. This cause having been reviewed by the court upon the motion of Rodrigo Caruso, appointed to counsel, to withdraw from further representation of the above named defendant and being fully advised of the premises therein it is hereby. By the way, you didn't even hear her mention this guy, Caruso. So I don't even know if she knew Rodrigo Caruso existed. He was on for a very short period of time, but she still should have gotten notification of that. Order and adjudge that Rodrigo M. Caruso is hereby allowed to withdraw from further representation of the defendant in the above styled case, and David Maldonado, Esquire, bar number 14536, is hereby appointed to represent the defendant in this cause. Attorney Maldonado's contact information is as follows: name, bar number, P.O. box / address, phone number, and email, all listed here in this filing from September 12th, 2025. Why does Sarah Boone not know this information? Why has this lawyer, if Sarah Boone's telling the truth, right, I have to put that caveat in here, because we know she could be embellishing, she could be not telling the truth, or something could get lost in the translation, the filings, but she has her tablet, she has the ability to call, she has other people we know calling, emailing, and knocking on doors for her. How does she not know about Maldonado? Is she being difficult? Potentially. But she should know this information. Peachy Williams said, but if she fires them, why do they have to talk to her? She's no longer a client. So as far as we've seen from all the documentation, including what Sarah Boone says, it doesn't say she's fired any of them. They have withdrawn for different reasons. And if you represent somebody from 2 months or 7 months, you should still let them know, especially if you introduced yourself like Attorney Adams did. If you're bailing, you should let them know why as a courtesy. Like, come on, we're still professional. If we're saying Sarah Boone's the bad one, let Sarah Boone be the bad one, not the lawyers, right? Just tell her. And if she says, no, you can't withdraw, or I refuse to let you off my case, well, you can ignore that because it's not her decision. It's the court decision if you no longer do this. Maldonado is already gone as well. I thought that was Caruso that was the quick one to come and go. I could be wrong. I thought Maldonado was the one currently on the case. But I could be wrong. I could be wrong. There's been so many in and out. But I believe Maldonado is currently the one. And if there was a new one, there should be a filing like this that says who the new one is with all of their contact information, so that we don't have a scenario, because you saw it in black and white, right? All of their contact information. We should not have a scenario where Sarah Boone can say something like number 4. She has no understanding of who her present appellate attorney is. She doesn't know the status of her appeal. The preparation of her initial brief, which is due in like less than 2 weeks. She would like pertinent information, like the name of her lawyer. Is that too much to ask even for Sarah Boone? Contact information, phone number, address. Come on. I don't care how difficult you are. You deserve that. Let me know if you agree or disagree. She's gone through near a dozen lawyers now. Do you really believe all of them were the problem? No, absolutely not. Do I believe all these lawyers were the problem? And there were some specific lawyers that were amazing lawyers that she had that we could tell from the first appearance when we listened to them. And then the issues came up, and it's clear Sarah Boone is a major part of the problem. But just because she's a major part of the problem doesn't mean some of the lawyers' actions are not great and not how they should be. And again, this should be, okay, so a lot of people are saying, no, some people are saying, yep, Maldonado didn't last a week. Other people said, I was wrong. It is Maldonado. So, but we don't know yet. But I think the point is like, come on. If I'm Maldonado, I'd be like, I've talked to Sarah Boone 3 times. I introduced myself. I told her, here are the issues for your appeal, and I told her I'll get her a draft. That's all I would need, right? If I was the appellate court, that's all I would expect. Be like, you've talked to her, right? You've been on the case for a month and a half. Have you talked to her? Come on. Just do your job. That's all I'm saying. I'm not saying you have to win. I'm not saying you have to be her best friend. I'm not saying you have to agree with her. Katie, after her horrible letter she wrote about the judge, what can he do? It seems like no matter what he did, she would have a problem. Yeah, it's kind of out of Kranick's hands. I guess, I don't think he still has jurisdiction to sanction this lawyer or anything, but if I was the appellate court, I would hate this. I would try to tell the lawyer, like, what are you doing? But I guess you don't really do anything until after the deadline passes, because theoretically he could be like, yep, here's your draft and welcome, I'm Maldonado. You've got 1 day to look at your draft. And while that's not great and that's not the wisest way to handle it, theoretically, would he be checking the boxes? Potentially. So we'll wait and see if he gets it all done or files another extension, which again, it's not quite the same as a trial court level. I think appellate attorneys, it's probably okay if they file extensions without telling Sarah Boone, because sometimes it's out of their hands. They just can't get it done in time. Not related, friendly note, you and Betterow recently discussed potential Proctor essay, text conversation referred to potential victim. He texted about as she, her. Friendly reminder, essay victims can be anyone. Yes, of course, they can be. Of course, that is true. Azam, Peter, can the judge stop assigning her any appeal lawyers at some point, like her trial, and will she have to represent herself for the appeal? I'm going to hold this question. Okay, Azam, I'm going to answer it in a second. Is this an issue across the board or just Sarah Boone? I would hazard a guess this happens a lot more than you would think. And while people think it's funny that it's happening to Sarah Boone or deserved that it's happening to Sarah Boone, I don't. I don't think it's deserved. Now, do I think she's going to win her appeal? Just to be clear, no, I don't. I think she's going to lose her appeal. But let's do it the right way so we can keep everything secured and appropriate and let justice be served and close the book on this case. Yeah, Charlotte said, Peter, there are a bunch of billboard signs in my town for a law firm that say, we will call you back. Wow, the bar is low. We put it in our fee agreements. You have the right to know what's happening in your case. You have the right to talk to us, to ask us questions. So the bar is low, inappropriately so, in my opinion. I'm not saying everybody in this chat is laughing, just FYI, because you guys are probably not. Most of you guys are saying, do the right thing, do your job. But there are people out there, laughing at Sarah Boone, which, again, she deserves her punishment. Jury convicted her. She did it. She deserves her punishment. But if there was a problem in the trial, she deserves a new trial and a second bite at the apple. So that's really what we're looking at here. And if she does lose this appeal, so what will happen is her initial brief will be filed. The state will answer that brief, and then she has 30 days to file a brief, which again, some continuations can happen there too. But this can take a year, 2 years, even though it's like a 30-day, 70-day, 30-day deadline. It very rarely gets done in that period of time. And then I also talked about she has a habeas petition that she could make ineffective assistance of counsel claims on and reiterate the problems with the judge, saying her federal rights were violated. Federal court's going to look at that. Again, slim to no chances there. So the initial brief, the habeas, and then the third option, which is really the second bite at the apple before the habeas brief. But I wanted to kind of separate it because I thought it was interesting for Sarah Boone's situation with all of her legal problems and with Azam's question here. Can the judge just stop assigning her appeal lawyers at some point? Theoretically, yes, but we are nowhere near that because not a single one of these lawyers, not a single one of these appellate lawyers so far, I think she's on, 3 or 4, has said this was Sarah Boone's fault. Not a single one has said, Sarah Boone's impossible. Sarah Boone won't let me do my job. Sarah Boone's asking me to do things that are illegal or unethical. There's a conflict of interest here. I can no longer represent her because of Sarah Boone. So that's a problem. If you're going to say she doesn't deserve appellate counsel, or we're not going to appoint it, or we're not going to pay for it, it's got to at least be her fault, right? It has to at least be her fault. You can't just say, well, all these lawyers keep getting out of criminal appeals or no longer taking appointed cases, therefore Sarah Boone doesn't get a lawyer. right? So that's not going to happen. But one of her other claims that could potentially be successful is ineffective assistance of counsel. That James Owens was brought onto this case, asked for a continuance, was denied by the judge, said he was not able to appropriately prepare for the case. Stuff came up during the case, like the expert's new opinion that he didn't have enough time to prepare for. They wanted to go find other witnesses that they couldn't find to call and subpoena appropriately and bring all these things because they couldn't get it together quick enough. And he didn't do an effective job because of the limited time. And by the way, trial lawyers don't usually take offense to this. James Owens would probably be like, go for it. Go for an ineffective assistance of counsel claim. I agree the judge should have granted that continuance. I wasn't able to be effective. But that 3850, 3.850, 3850, all the different names that we call it here in Florida as the state level ineffective assistance of counsel claim, that's a pretty low bar too, unfortunately. But in order to go forward on that claim, guess what? The state of Florida does not entitle you to have a lawyer paid for you to do that. So while that right on appeal for this initial brief, the state of Florida is going to pay for her to have a lawyer and make sure she has a lawyer for this initial brief. For the 3850, for which she could have a very real claim, she's not going to get a lawyer paid for her. That's not something that's guaranteed. So she's still writing letters in the appeal process. Once she realizes if she loses this initial appeal in an initial brief, her next bite at the apple is ineffective assistance of counsel, and she is not, for the second time now, going to have a lawyer there appointed and paid for. So what is she going to do? Are we going to see another wanted ad put up on court TV, another letter written by Sarah Boone? Is she going to, go on news programs or try to grant interviews with people or something in an effort to get a lawyer to swoop in and help her with this ineffective assistance of counsel claim? Most criminal defense lawyers believe that they can take a look at the trial and see if the lawyer screwed up, and if they screwed up anywhere, even if it's in preparation, that, they have a valid and legitimate 3850. Or will we come to a point in time where Sarah Boone, once again, represents herself in the 3850? That's what is still to come in this case. This case is not over. There are still multiple bites at the apple, and I hope all of Sarah Boone's rights are protected so that if and when we get to a final resolution and she exhausts all of her options, if in fact she loses over and over again, that she's done, the process worked appropriately, and she spends the rest of her life in prison, if that's how it ends. But lawyers should do the right thing. That's always going to be something I say, even as a lawyer. Some lawyers don't like saying lawyers screw up or lawyers do the wrong thing or whatever. But I welcome it, because to be ethical and to be responsive and talk to your clients, like, come on, that's not something that's so difficult. An appeal lawyer stated that they don't have to contact her until they have read her appeal. Is that true? Until they have read her appeal. I don't know what that means. You mean written her appeal? And here's the question, okay? Just so you know, there are probably some lawyers that say you never have to talk to your client. I think there are probably lawyers that would say that. I think it'd be unethical in Florida, especially at the trial court level. But every lawyer is going to say things differently, right? And there are certain things that are codified in the rules, and there are certain things that are not. Every lawyer has a different moral and ethical compass. That's all I can tell you. And what you get here on my channel is my ethical and moral compass, which is I treat others how I want to be treated, right? I love my neighbor. I would hate it if I had a lawyer that wouldn't talk to me. I would try to be reasonable, of course. I would try not to be annoying. I would try to only ask good questions. It's how I treat doctors too, right? I want to know what's going on. Can you talk to me a little bit? Some doctors probably think you only need to take 30 seconds with somebody to explain to them what happens. Some people think probably doctors should take 2 hours. Where's the reasonable line? Depends on the lawyer, and you can pick the lawyer. You can pick the lawyer or doctor that you want. But that's the way I look at it, right? So other lawyers can say, oh, you don't have to talk to your clients. Fine. I don't know how you represent somebody without talking to them. Now, I could write an appellate brief without talking to a client. Yes, I could. I absolutely could. But if I was the client, is that what I would want? Would I want some lawyer to just put the appellate brief together, not even ask me my opinion, not let me read it, not let me comment? Now, if they've got to do their job as a lawyer, it's just like a surgeon. I'm not going to tell them how to do their surgery. I'm smart enough to figure that out, right? Or if they say, oh, you don't need this treatment, you need that, or you don't need this pill, you need that pill. I'm not going to say, no, I want that pill. No, you do some research. Maybe you can disagree with them, get a second opinion. I think all that's perfectly fine as well. But this is my opinion on how I look at it. I think it's absolutely inappropriate to represent somebody even at the appellate level without talking to them. I think there's definitely a very major difference between how often you talk to them and the type of conversations an appellate lawyer would have with them versus me, somebody who's trying the case and litigating the case in its entirety with them. Somebody in my position will talk to them a whole lot more than an appellate attorney. But a lot of times, you have a certain relationship with your lawyer that tried the case. Sometimes they'll talk to the appellate attorney and then they'll translate to you. I've done that before in cases. I'm doing it right now in a civil case. In a bad faith case that's going up right now to trial soon, I'm a go-between a little bit because I have a better relationship with the client than the appellate attorney does. So that happens too. But you're still talking to your client and making sure they understand, right? That's the way I look at it, right? Anybody can disagree with me, and I'd be happy to talk to any lawyer about it. I'd love to talk to a lawyer about it because I feel like they would squirm in their chair trying to defend the position of, I don't need to talk to my client that I'm getting paid on behalf of either by them or by the state. Are you volunteering? Absolutely, as clearly as I can ever say no. Do I think lawyers should be forced to take cases they don't want? No, I'm not saying that at all. But these lawyers get on these lists knowing they could be appointed for very difficult cases. Other lawyers choose to be public defenders, doing God's work. State attorneys, even these government lawyers, are overworked and underpaid. Okay? So don't get it twisted. I'm not saying every lawyer should be forced to take cases and take amounts of money or no pay to do it. It's not what I'm saying. But when I choose to take a case, I am going to talk to that client, whether I like that client or not. And I'm going to fight as hard as I can for every single client I have. Okay? Whether I'd be friends with them or not. All right. I think that's enough there. I felt like I was a little bit on a soapbox, so I apologize for that. She lied about her lawyers not talking to her before. I think there was some truth to some of the accusations she made to some of the lawyers. I think some was absolutely wrong. I think she wordsmithed some to not technically lie, but make it seem like they weren't talking to her. Absolutely, there could be embellishing here. And that's why I'm saying, if a lawyer comes out and says, I introduced myself, I told her I was working on the appeal, that might be enough. That might absolutely be enough. All right. That's all we got. Hopefully you guys enjoyed the Sarah Boone update. Send me any questions you have. Keep an eye out if you live in Orlando to the local news here. Keep an eye out for that. You might see somebody you recognize at some point. But make sure you guys hit that like button. Make sure that you're subscribed to our page. I am probably going to do another video tonight on some updates in Karen Reed. I see them coming in, and I see people sending questions. So if you have questions on all the stuff going on in Karen Reed's case right now, you can hit me up on Twitter at LawyerYouKnow, on Instagram at Tragos Law, or on the YouTube community page if you guys have questions. So I think there's going to be a twofer today, video-wise. So keep an eye out for that tonight. You guys are the best, and I am out of here. Peace. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, X, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast featuring new episodes every week. And if you have a case that you want to personally talk to us about in your life, if it's a personal injury case, wrongful death, catastrophic injury, car accident, truck accident, or slip and fall case, please email us at lawyeryouKnow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.